Good morning, ladies and gentlemen. My name is Mulebran Sirani. I am a lecturer for Family Law Code PVL2601. And welcome, ladies and gentlemen, to PVL2601. For the sake of this presentation, this class rather, we will be focusing on section 1, and we'll be mainly focusing on study unit 1 of our study guide, which is chapter 1 of our chapter 3 of our textbook. I hope you have your textbook and your study guide with you as we will be maneuvering on this study unit. So I'm going to share on my screen. Yes, I'm going to share on my screen the main focuses that we'll be focusing on. So just to give you a highlight or a mind map of what we will be focusing on or what we'll be tackling. So study unit 1, which is the legal requirement for a civil marriage, is what we'll be focusing on. That will be our study or focus for this session. And at the end of the session, since this is a recording, I advise that you give your questions relating to the study unit. Please make sure that your questions relate to the study unit. Okay. So we need to understand what a civil marriage is. A civil marriage is a monogamous and only persons of the opposite sex can enter into it. It is governed by the common law and various acts, meaning legislation, statutory, and fully recognized by South African law. So one would summarize it as a monogamous heterosexual voluntarily, and it excludes other people. So just for clarity's sake, need to understand that an engagement is not a legal requirement for a civil marriage. You see, people usually, before they enter into the marriage, the men usually propose to the woman, asking for her hand in marriage. So note that an engagement is not a legal requirement for a civil marriage. So now that we have that out of the way, we will go straight to the first requirement for a civil marriage. The first requirement that we'll be focusing on is that among the parties, both parties rather, must have the capacity to act. Meaning that they must be in their sober mind to be able to perform the act of marriage, to accept, to consent, to perform this act or entering into the marriage. However, there are certain groups of people who their capacity to act is rather more focused on or has more or different requirements as compared to I would say a person who has full capacity. For example, a declared prodigal can enter into a civil marriage without a creator's consent. You see this in the decision that was made by Pinar versus Pinar in this case, where Judge Delivers stated that a person under curatorship can enter into a civil marriage without their curator's consent. The second group of people is the mentally ill persons. The mentally ill person can enter into a civil marriage during a lucidium intervarium, which means that they are temporarily improved. There's a temporary improvement of the patient's condition after traumatic brain injury followed by a second deterioration. So where, for example, there is a report stating that the person who was diagnosed with a mental illness, there seems to be an improvement on that person post the traumatic incident or the traumatic brain injury. That person can also enter into a civil marriage. The third group of persons who can enter into a civil marriage are persons under curatorship due to disability or chronic illnesses or due to incapability of managing their own affairs. This can be a person who, for example, is on chronic medication, or this person cannot manage their own affairs. It could be manage their financial, financial affairs. So these people can enter into a civil marriage without the consent of their curator. Now, the last group we're going to focus on this requirement is the minors. The minor can enter into a civil marriage without the consent of the parent or their legal guardian. So with regards to the minor in this case, as you know, they vary by age. So below the age of 7 years old, there is no capacity to enter into a marriage. Between 7 and 18 years old, there is limited capacity. Section 26 of the Marriage Act states that boys below the age of 18 and girls below the age of 15 need the consent of the Minister of Home Affairs over and above the consent of the family to enter into a civil marriage. Section 24A of the Marriage Act states that a civil marriage entered into by a minor without the necessary consent is not void, but may on application be dissolved by the court. So, for example, if a minor entered into a marriage without the necessary consent, meaning the consent of the Minister of Home Affairs or the consent of their family member, which maybe is their guardian, the marriage is not void. However, the marriage can be dissolved by an order of the court. So in such an instance, there needs to be an application to the court to dissolve the marriage. Okay, now we move on to the second requirement, that there must be an agreement or there must be consent, meaning that both parties must agree to being into them, consenting to the act of them entering into a civil marriage. So now we're going to focus on factors that have effect rather on the consensus. The first factor is the mistake concerning the identity of the party, which in Latin is an error in personam. And there is another mistake concerning the nature of the juristic act, which is the error in negotiation, meaning that, for example, let me firstly go to the first factor, which is the mistake of the identity of the other person, meaning that you might be consenting to marry, you may be agreeing or consenting into getting married to a tall guy or a short woman or a tall woman, or like the description of the person. However, when you get to meet that person, you find out that person is not exactly how they describe themselves. Can usually happen, say, for example, in the dating apps, one would have a certain description of themselves and then would be interested in that description and consent to marrying that person. But in person, when you meet that person, you find out that person is not the person you agreed to marry to. The second factor, which is the mistake concerning the nature of the juristic act, meaning that, for example, you were consenting to a certain, what do you call, you were not maybe agreeing into actually getting married to that person. And that could be the other mistake of the nature of the jurisdiction act that can be identified, which is a factor. And there's an effect on the validity of a civil marriage under mistake. Okay, so it is unclear whether such a marriage would be considered void or voidable. So we move to the second factor. The second factor which has effect on consensus is misrepresentation, which is basically similar to the mistake of the identity of the other party. But here it details on other factors that one might have consented to regarding the marriage. However, that would not be the case, or there would be no truth in that. For example, if a party says that they are that they don't disclose the fact that they are pregnant while you're getting married to them, and then that child is not your child. Or even if it is your child, you are not really given the truth of the matter consenting into the marriage. For example, say, for example, a woman, like I just mentioned, does not disclose that they are pregnant, or doesn't disclose that they can, for example, they are working, or that they have they are able to do certain things, and the other party is misled into thinking that everything that they know regarding the marriage or regarding the other person entering into that marriage is of truth. But it happens that there is no truth in that. Then they have that, what that other person stated as a lie, as the truth entering into that marriage. I hope I make sense. So let me just read it out for you guys so that I make it more clearer. The misrepresentation where one party misleads the other prior to the civil marriage by making untruth statements. So we see where it goes in. Okay. So the effect of a misrepresentation on the validity of a marriage under the misrepresentation is that the marriage is voidable, and only a serious misrepresentation can lead to a civil marriage being set aside. So the seriousness of the misrepresentation usually is declared by the court. So in this case, the matter rather would have to be brought before the court, and the court would see if ever there is a seriousness in the misrepresentation that led the other party to enter into that marriage, and then the court would then set aside the marriage. So Now we move on to the third factor, which may have effect on the consensus, which is duress. So I'm going to explain what duress is. Duress is where one of the spouses has been forced into consenting to a civil marriage, whereby, for example, where you are pressurized into a consenting to the marriage, or yes, agreeing into entering into a marriage, where somebody, for example, has okay, let's read out this case. I hope you also have a textbook whereby you can see, even in the case of Smith versus Smith. So I'm just going to give a brief summary of the case and what the court had decided regarding this case. In this case, a woman was coerced into such an extent, was forced into such an extent by their father, meaning her father, the woman's father, and prospective husband, that she was completely dazed and lacked any will of her own during the wedding. Now, the court, looking at these factors, concluded that the jurors rendered the marriage voidable. Therefore, the court set aside the civil marriage. So in this case, it explains that the father of the wife and the husband, they dazed the wife and made her believe that she didn't have will of her own in matters regarding the marriage. And this happened during the wedding. So now we move on to the fourth, which is the last factor, which has effect on the consensus, which is the undue influence. Undue influence is where one party has been influenced, or his choice rather had been persuaded into entering into a civil marriage as a result of influence. This one is a bit, you can see that it's a bit similar to duress. In duress, one is not given, it's made to believe that they do not have a choice to not agree to the marriage. And in this one is forced, or they are persuaded into entering into the marriage. So the effect on this type of, where this factor is approved, the marriage, the civil marriage under undue influence is voidable. There is no direct authority to this, the marriage being voidable. So now we move to the third requirement of a civil marriage, which is lawfulness. The civil marriage must be lawfulness. Note that unlawful civil marriages are void. Based on relationships either through consanguinity, which is the blood relationship, and affinity, which is a relationship by marriage. So we're going to try to break it. I'm going to try to break it down to you so that you have a clear understanding of what consanguinity is and what affinity is. So consanguinity is a relationship created by blood relationships. So we have a direct line of consanguinity relationships, and we have collateral line of consanguinity relationship. So on the direct line of consanguinity relationship, these are between a relationship between the parents and the children, meaning that the parents cannot get married to their children. If a parent marries their children, then that marriage is unlawful. So there needs to be lawfulness for a civil marriage to be considered valid. Where there is a marriage of collateral line, marriage under consanguinity, this is a relationship whereby there's blood-related siblings, meaning a brother and a sister, and where there's a relationship of an uncle and an aunt, and a relationship of a nephew and a niece. Such relationships, such marriages are not, they are unlawful relationships, which will not be considered as a legal requirement for a valid marriage. Now, under affinity, we have affinity relationships. We also have a direct line and a collateral line. In affinity relationships, these are marriages created by marriage. For example, parents-in-law, stepchildren, brother-in-law, sister-in-law. So now I'm going to set each according to their line. So the affinity direct line is a relationship between the parents-in-law and of the stepchildren, excuse me. And the collateral line of affinity is the relationship of a brother-in-law and a sister-in-law. So I'm going to read out the rules of these marriages, of these relationships rather. Consanguinity relationships is a blood relative in the direct line may not marry each other. One may not marry any member of his or her ascendant or descendant. Ascendant are your ancestors, your those that came after your ancestors, and meaning your parents, your uncles, and so forth. And now it comes to your descendants are those that came after you, meaning your children, your great-grandchildren. The blood relatives in the collateral line may not marry each other if they are related to the common ancestor in the first degree, meaning the first generation, what I just mentioned previously, meaning that if, for example, a nephew and a niece, your nephew and your niece from your brother or your sister, they cannot marry each other because they share the same ancestor, which is your parent. That is a common ancestor in the first degree, which is the first generation. One may not marry their siblings, their children, or their grandchildren, meaning you, as an ancestor of the first degree, you cannot marry your siblings, you cannot marry your children, and you cannot marry your grandchildren. Note that one may marry their cousin as the relationship in the second degree, the common ancestor being the grandparent. So in affinity, we're going to focus on the relationship of affinity, where persons related to each other through affinity in the direct line may not marry each other. One is not allowed to marry blood family members through the direct line or of his or her spouse, meaning, for example, their mother-in-law, their father-in-law, or their stepchildren. Which means, for example, if you were to marry your wife, or if you were a man, you marry your wife, and if you were a woman, marrying your husband. You cannot marry your mother-in-law or your father-in-law. Or if your spouse comes with their child from a previous relationship, you cannot marry that child. So now we're going to move to the persons who are related to each other by affinity in the collateral line may marry each other. One may marry their sister-in-law or brother-in-law or a cousin or a niece or a nephew of your spouse. For example, if you are a male now, a man, and you are married to your wife, you can marry their brother-in-law or their sister-in-law, or you can marry their cousin, or you can marry their nephew or their niece. That is allowed. That renders a marriage lawful. So the adopted children, an adopted parent is not allowed to marry his or her adopted child. This is in South Africa. Okay, because I've seen in certain countries where adopted parents did marry the adopted children. But in South Africa, this is not allowed. Separated adopted children who are not related to each other within the prohibited degree may marry each other, meaning the separated adopted children may marry each other who are not within the prohibited degree of relationships. An adopted child may marry their stepbrother or stepsister, provided they are not related to each other within the prohibited degrees of relationships. Meaning, for example, if you are now you are adopted and you have a stepbrother or a stepsister, you can get married to them. But it is only when you are not within the prohibited degree of relationships. Now we move on to the guardian. The guardian, the legal guardian and his ward, meaning the minor, which they are under guardianship with, may only marry each other with the consent of the High Court. Say, for example, now you are a guardian of a minor and you can apply to the court to get married to your ward. That's what they call a person you are under guardianship, who's under your guardianship. You will need the consent of the court to validate your marriage. So now we move on to this. Okay. If you can go to page 26 of your textbook under lawfulness, I will you see 3.4.3. It states that persons who are of the same sex. Remember that civil marriages are monogamous and are of persons of opposite sex. So a person of the same sex cannot enter into a civil marriage, but can enter into a civil union. You see that in the other chapters to come, we will be tackling on persons who are of the same sex who enter into the same who enter into a marriage. So now we move on to the fifth requirement. We've done lawfulness. Now we move to the prescription of formalities, which is the fifth requirement of a civil marriage. So in this requirement, we will be focusing on the marriage officer, the times of solemnization of the marriage, and section 29, subsection 2 of the Matrimonial Act. So under marriage officers, the Marriage Act sets out the prescribed formalities of a civil marriage, and a civil marriage may only be solemnized by a marriage officer. Anyone who purports to solemnize a marriage without having the necessary authority to do so, and an unauthorized and then they authorize a marriage, such a person is prohibited to do so. So one must be, for you to be a marriage officer, you must be authorized first to be a marriage officer. Not anyone can be a marriage officer. There are certain rules and requirements that one needs to fulfill first for them to be a marriage officer. So you must be very careful if you get to choose to be in a civil marriage. You must first find out if the marriage officer is authorized to solemnize your marriage. So the marriage officer, the Minister of Home Affairs may also appoint a person as the marriage officer. Such a person includes any officer in the public, diplomatic, or consular service, and a minister of a religious or a religious organization, or anyone holding a responsible position in a religious dominionship or organization for the purpose of solemnizing marriages in accordance with Christianity, Jewish, Muslim, Indian, and Indian religious rites. So the Minister of Home Affairs appoints the marriage officer. So you must find out if your marriage officer is authorized by the minister, or authorized and also appointed by the Minister of Home Affairs. Even when you get to have a client who comes to you and then says they want to be married, this is one of the prescribed formalities that you also need to advise them on regarding their marriage officer, so that they at the end, for example, in this case of a dissolution of a marriage, their marriage meets all the legal requirements for a valid marriage. So now we move to the second prescription of formalities, which is time of solemnizing of the marriage. The first one that we would focus on is formalities preceding the marriage ceremony. So on page, you can get this on page 31 of your textbook. I'm going to read it out from the textbook. So in this scenario, given that when is when someone wishes to raise an objection to an intended civil marriage. This person must lodge the obligation with the marriage officer who is to solemnize the marriage. The marriage officer must then inquire into the grounds on which the objection is based and may only solemnize the marriage if he or she is satisfied with the no lawful impediment to it. So, for example, if you were to object to that marriage at the ceremony, you wish to raise an objection, you must raise it with the marriage officer, and then the marriage officer will inquire on your objection and see if ever they are satisfied with the objection. If so, then the marriage will not be considered a lawful marriage or would not be entered into. And if they are not satisfied, the marriage will proceed. I don't know if you are aware of, if you see this American marriages, American movies rather, where the ceremony where they ask if anyone is against this marriage and the other one would rise up and say, objection. Yes, that's basically the scenario. That's basically what this requirement states. So now, even in this, the formality preceding the marriage, the marriage officer will not solemnize the marriage unless both parties produce their identity documents or a prescribed affidavit. Now we move on to the third factor of the prescribed formalities, which is formalities during the marriage ceremony. The previous one is a formality preceding the marriage ceremony. Now we are focusing on the formalities during the marriage ceremony. So the Marriage Act requires that both parties must be personally present at the solemnization of the civil marriage, meaning that both parties cannot get married to each other when the other one is absent. So both parties need to be present. No one can conclude a valid marriage through a representative or by proxy, meaning that you cannot send somebody to stand on your behalf in a marriage position at the marriage ceremony to stand on your behalf. You cannot even send proxy for one to enter into the marriage on your behalf. So the civil marriage may be solemnized at any time and on any day of the week. But a marriage officer is not obliged to solemnize a civil marriage at any time than between 800 hours, which is 8 a.m. in the morning, and 1600 hours, which is 4 p.m. in the evening. Section 29, subsection 2 of the Marriage Act states that the marriage must or shall be solemnized in a church or other building used for religious services or in a public office or private dwelling house with open doors and in the presence of the parties themselves and at least 2 competent witnesses present. However, the marriage may be solemnized anywhere else if either of the parties cannot be present at any of the above-mentioned places because of the serious or long-standing illness. So what this section states is that it gives you an idea, it provides the structure of the place whereby the marriage can be conducted. It states of religious, it's a building. Firstly, it says a church or a building used for religious services, or public office, or private dwelling house, meaning your B&B or your lodges and so forth, with open doors in the presence of parties themselves, meaning the parties must be present. We just mentioned it earlier that you cannot appoint a representative to stand on your behalf for your own marriage, to enter into your own marriage, and that they need to be at least 2 competent witnesses who would witness and attest to your marriage. Now, the Act now, however, there is an exception to the rule whereby, for example, the other person maybe cannot travel, or they are not in a good state of their well-being, or it's serious, and this person cannot be in those places. So that's the exception to the rule regarding Section 29, subsection 2 of the Marriage Act. So, for example, one can also be married by the beach. You can see people, that's not a building. People can get married at the beach or in a garden and so forth. So now, in the case of ex parte DAO, you'll see that in chapter 3, page 31 of your textbook. I'm trying to get. So in ex parte DAO, it was held that this is not the case. Where a husband applied for alignment of his civil marriage on the grounds that it had been solemnized in the garden or a private dwelling house, and not in a house as required by Section 29(2). Judge Brumi examined the objection sought to be achieved by the provisions and changes which have taken place in the formalities required for the conclusion of a civil marriage through the centuries, such as the abolition of the need of the publication of banners and special licenses to men, and concluded that the objection of the provision had been to avoid clandestine marriages. All the provisions had been previously served to inform the public of an intended civil marriage have been abolished. He further pointed out that in terms of Section 24A of the Marriage Act, a civil marriage entered into by a minor without the necessary consent is not void, but may, on application, be dissolved by a court. Similarly, Section 26 provided that boys below the age of 18 years of age and girls below the age of 15 age cannot conclude a civil marriage without the permission of the Minister of Home Affairs. But if such consent is not obtained, the Minister of Home Affairs may vary the marriage. Judge Brumi felt that in the sense of situation, there were the far more compelling reasons to treat the marriage as void ab initio, meaning from the beginning of the marriage. Should have been considered void at the beginning of the marriage, but the Act did not do so. He concluded that a civil marriage is such an important relationship, and the consequences of the degree of nullity are so far-reaching that the legislator cannot have intended for the marriage to be void if the two-letter word was not compiled with. The application was accordingly dismissed, meaning that the application of the husband, where he said that he wants annulment of the civil marriage on the grounds that the marriage was solemnized in a garden of a private dwelling place and not as prescribed, and not in the places as prescribed by Section 29(2) of the Marriage Act. His application was dismissed. So in all marriages ceremonies, the prescribed marriage formula must be adhered to. The marriage officer must put the following questions to each of the parties separately. Do you, A or B, declare that as far as you know there is no lawful impediment to the proposed marriage with C and D here present, and that you call all the present two witnesses that you take C and D as your lawful wife or your husband? I take it if you see even in the movies or if you ever did attend a wedding, you always hear that the marriage officer would say these words, would allow the parties to the marriage, meaning the potential, the wife and the husband, to say this prescribed marriage formula. So this marriage formula is to be presented or allowed each party to say. So now we move to the last requirement of the marriage, which is the registration of the civil marriage. The registration of a civil marriage is usually done after the wedding ceremony. The marriage officer who solemnized the civil marriage, the parties thereto, and two competent witnesses must sign the marriage register immediately after the wedding. The marriage officer then sends the marriage register to a regional or a district representative of the Department of Home Affairs. So now you can see how it is important to have a marriage officer who is appointed by the Minister of Home Affairs and is authorized to perform the marriage ceremony. Because now, after the wedding ceremony, they have an obligation now to further assist you in registering your civil marriage. Meaning, as I have read earlier, that the marriage officer now has to take the document that has been signed, which is the marriage register, and send it to the regional and the district representative of the Department of Home Affairs. A copy of the entry in the register serves as prima facie proof that the civil marriage has been solemnized. Non-fulfillment of the registration requirements does not affect the validity of a marriage, and registration can be effected post-nuptially. So, meaning that if that is not done immediately, it does not affect the validity of the marriage. However, the registration must be done, can also be done post-nuptial. A signed marriage certificate serves as prima facie proof as we have, as I have stated earlier, it serves as proof of the existence of a civil marriage. So you having your marriage certificate or you advising your client to have a marriage certificate, it serves them as proof, or you as proof if you are a party to a marriage, that indeed you are a party to existing civil marriage. In the absence of a civil certificate, the existence of a civil marriage can be proved by means of other evidence. I don't know if you are aware of the chaos that has been happening in customary marriages where the husband's family or the wife's family would dispute the existence of their marriage and how they need to prove that indeed there was marriage, especially when they did not register their marriage. In this case, it's also provided for in the civil marriage, whereby if there is no proof of the certificate of the civil marriage, there are other evidence that can be brought to prove the existence of a marriage. In civil marriage, in the previous customary cases that have been brought to court, we see how there is a letter of lobola, the letter of negotiation of lobola. There's also a videography evidence. There's also photos as well to prove that indeed there was an existing marriage. So that can also be taken in as other evidence in a hearing of a court in the dispute of the existence of a civil marriage. This brings us to the end of our study. We have now completed study unit 1 of our study guide, the legal requirements for a civil marriage. I hope everything was clear. If you have any questions, please send your questions in the description box so that we are able to send to answer your questions. If you're unable to send in that description, you can also send to my email, which is in this tutorial letter, or send into Ms. Munaring's email address. I hope this session was fruitful and it was clear. If not, like I just previously said, you can send your email, and I wish you all the best in the study unit. Have a lovely day. Thank you.